call this meeting to order. Welcome to meeting number 90 of the House of Commons Standing Committee on Agriculture and Agri-Food. I'll start with a few reminders. Today's meeting is taking place in a hybrid format. The proceedings will be made available via the House of Commons website. Just so you're aware, the webcast will always show the person speaking rather than the entirety of the committee. And of course, screenshots or taking photos of your screen are not permitted. Pursuant to Standing Order 1082 and the motion adopted by the committee on Thursday, October 19th, 2023, the committee resumed its study of efforts to stabilize food prices. I'd now like to welcome our witnesses for this panel. With us today from the Competition Bureau Canada, Anthony Durocher, Deputy Commissioner, Competition Promotion Branch, and Bradley Callahan, Associate Deputy Commissioner, Policy Planning and Advocacy Directorate. So welcome to our committee.
To welcome to the committee. We have today, I think Mr. Williams will be joining in a moment for Mr. Steinley. So welcome to the committee. And we have Mr. McLeod subbing in today. There's Mr. Williams, welcome to the committee, and we have Mr. McLeod subbing in for Mr. McDonald. So welcome, Mr. McLeod. Colleagues, we will be with the Competition Bureau for the first hour of our study, and then we'll be going in camera for some committee business. But thank you to the folks from the Competition Bureau. We're going to allow for 5 minutes. We have a little bit more time, so if you need a little bit more time, I'll be flexible on that, and then we'll turn it over to questions from there. So over to you, gentlemen.
Bonjour, Monsieur le Président.
Hello, Mr. Chair and members of the committee. My name is Anthony Durocher. I'm the Deputy Commissioner of the Competition Promotion Branch. Joining me today is my colleague Brad Callahan, Associate Deputy Commissioner of the Policy Planning and Advocacy Directorate. I'd like to begin by recognizing the importance of your study. We believe it has been invaluable to informing and advancing the public discourse around food affordability. And the testimony at this committee have benefited the Competition Bureau in our efforts to protect and promote competition in the grocery sector. The Competition Bureau is an independent law enforcement agency that protects and promotes competition for the benefit of Canadian consumers and businesses. We do this because competition drives lower prices and innovation while fueling economic growth. We administer and enforce the Competition Act by investigating and taking action to address anti-competitive business practices that harm consumers, competition, and our economy.
23, the Bureau released its Retail Grocery Market Study report. Our report found that grocery prices have been increasing at their fastest rate in more than 40 years, and since late 2021 have been significantly outpacing the general rate of inflation in the Canadian economy. Additionally, the retail grocery industry has become much more concentrated over time. Today, most Canadians purchase their groceries from only a few grocery giants who operate most grocery store banners, including the top discount chains. Our report makes a number of principle-based recommendations to federal, provincial, and territorial governments to improve competition in the grocery industry. They include stimulating innovation and supporting the growth of independent grocers, as well as the entry of international grocers through government policies and programs, limiting and potentially banning property controls. Lastly, introducing accessible and harmonized unit pricing requirements. We continue to be actively engaged with policymakers on our report's findings and its recommendations. We recognize that food price inflation remains a significant issue for Canadians, and we need to approach our work in the grocery industry with heightened vigilance and scrutiny to ensure that Canadians benefit from greater choice and more affordable groceries. This includes by thoroughly and quickly investigating allegations of wrongdoing. To that end, we are actively pursuing an enforcement investigation in the grocery sector relating to the use of property controls. Recent amendments to the Competition Act, particularly through Bill C-56, have given the Bureau more tools to protect and promote competition in Canada and mark a key step in modernizing Canada's competition law. The Bureau is committed to using the new tools made available through these amendments wherever necessary to protect competition. Further, as you know, Bill C-59 contains several other amendments that will, if passed, further strengthen Canada's Competition Act. Before fielding your questions, I would note that the law requires the Bureau to conduct investigations in private and keep confidential the information we have. This obligation may prevent us from discussing past or current investigations. I would like to thank the committee very much for the invitation to appear today, and we look forward to your questions.
Okay, thank you very much, Mr. Durocher. Mr. Callahan, we'll do exactly that. I'm going to start with, is it Mr. Williams? Okay, we're going to start with you for up to 6 minutes, please.
Thank you very much, Mr. Chair, and welcome Competition Bureau to this committee. For those listening at home, I always think of the Competition Bureau like the Sheriff's Office. So we have the Sheriff, and then today we have the Deputy. So nice to have you to committee here today, sir. I want to focus starting with mergers and acquisitions. Your report, your grocery study report, was very well done, by the way. And it talks about one glaring point was that in 1986, we had 8 Canadian-owned grocery chains, where in 2024, we have 3, and that have 80%. And 2 American that have entered the market since 1986. So we have Walmart and Costco that each have around 10%. During your time with the Bureau, you always act with the laws or that you're given, the powers that you're given to look at these mergers and acquisitions. And when we look over the last 8 years, there were 3 in particular that you reviewed. One was Metro buying Jean Coutu, and then we had Sobeys, who acquired both Farm Boy and Longo's. Did you, yes or no, make a recommendation to approve those mergers, each one of those that you looked at?
So the Bureau reviews mergers, but does not necessarily approve them. It's a more question, do we oppose them or challenge them or no? In recent years, there are some mergers that we have not challenged because we haven't had the evidence, and others, as an example, Loblaw's acquisition of Shoppers or Sobeys' acquisition of Safeway, or even before then, Provigo's acquisition by Loblaw's, were cases where we had remedies and divestitures for the sale of stores or assets to try and preserve competition.
So maybe a direct one that you were involved in the last couple of years. Did you approve the merger of Rogers and Shaw? Yes or no?
No. That is a transaction that we sought to block at the Competition Tribunal, but the Competition Tribunal ruled in favor of letting the merger proceed and against our application, so the merger did proceed notwithstanding our attempt to block it.
And so the point I'm making is what we've done in our research and found is that mergers and acquisitions result in higher prices. Just earlier last month, we did see that Rogers announced they're increasing their cell phone rates by $9 a month for consumers. So when we look at data for North America, M&As result in higher prices 95% of the time. And when we look at the powers that your Bureau has to look at M&As, and we look at the consolidation, the massive consolidation of this industry from 1986 to 2024, to only have 3 Canadian companies competing is probably a good reason why prices are up. Do you agree?
Well, certainly when we talk about merger review, we often say it's the first line of defense for competition in the economy because it can lead to structural changes in industries that can result in higher concentration and lower competitive intensity. So harmful mergers would typically result in higher prices, less innovation, less choice, and can be harmful. Depends on the evidence for each merger review, of course.
We only have so many independents left. About 6,000 independent grocers left in Canada. One in Alberta is the Friesen Brothers. Talked to them quite a bit. You know, that's one that we'd want to see grow. That's a Canadian grocery store that we'd want to see get more market share. The bigger problem we have right now is it's vertical integration. So some of these bigger grocers, Sobers and Loblaws especially, have control of also the wholesale market. So it's not just the grocery, it's the wholesale. Do you recommend, or do you feel that we need to really look at that side also of the business, not just the grocery and the retail, but how that wholesale market is also dictating prices?
Yeah, and thank you for the question. That's certainly something we flagged in our report as being top of mind for independent grocers, is the fact that in many cases they're beholden to purchasing their product from vertically integrated competitors, the larger competitors, because they don't have the scale required to make those purchases themselves. Of course, some participate in buying groups to help make those purchases, but certainly from our perspective, we're alive to the fact that there is a vertical integration along the chain, and independents in some instances have to rely on that. And there is a need for us to be vigilant against potential anti-competitive conduct in that regard by foreclosing access or otherwise harming competitors by using by knowing that they're relying on your inputs to compete.
Another phenomenon that's happened in the last while, it's happened for a while, but more advanced now, is shrinkflation. So manufacturing shrinking products. When we talk about wholesale, we're also talking about Loblaws and Sobeys also manufacture products. So we have President's Choice, we have your compliments. Part of that has been shrinkflation as well. One of your recommendations from your report was to make shrinkflation illegal. When the government introduced their legislation to create more powers for the Competition Act, did they consult with you, and why did they not make shrinkflation illegal?
So we don't tackle shrinkflation head on in our report, other than recognizing that it is an issue. We heard about it from many Canadians. And in many ways, shrinkflation can be a phenomenon akin to a price increase or the exercise of market power in the marketplace. So from our perspective, competition is a key solution to deter that, because at the end of the day, the more competition you have in a marketplace, including amongst manufacturers, the less ability there is for firms to raise prices or otherwise reduce the value of goods, including through shrinkflation.
We're at time. Thank you very much, Mr. Williams. Thank you, Mr. Drochet. Maintenant, Monsieur Drouin pour 6 minutes. Allez-y, s'il vous plaît.
Mr. Drouin for 6 minutes. Thank you to our witnesses. It's not the first time you have been at our committee. Just a few questions. The last time you were here, we had also some testimonies from the major CEOs. They told us repeatedly, don't worry, we will give the Competition Bureau all of the necessary documents for them to be able to properly assess the prices in order to determine whether or not there were extra or exceeding profits on food. Mr. Whalen at the time said that they did not make any profits on food. It was on medication, which is not much more noble, to be honest. With C56, do you now have the power to ask for this kind of information? The last time you were here, you told us that you don't have the power to demand that companies provide that documentation. What's the case now? Indeed, now with C56, we'll have some power in order to demand legally certain documents. With regards to the collaboration from the grocers for our market study, it varied and it was incomplete. That said, there was something that was very important to us, and that was to study the financial data and to look at the profit margins and isolate them for food products. Most retailers sell various different products. With the information that we received, we were fairly confident. Looking at the evolution of the margins over the last 5 years, so 2017 to 2022, the gross margin of retailers increased in a modest way, but also significantly. So 1 or 2% increases is what we're talking about. This industry is about volume, and so 1 or 2% could actually be quite significant for Canadians. With regards to the new powers that you have under C-56, there's talk about a dominant position. What's the difference between the way you used to work and the new powers you have under C-56? This week, a professor talked about the concentration within the market, which could have a dominant position vis-a-vis consumers. So what power will you be able to exert with that dominant position, and what does the law allow you to do now that you couldn't do beforehand? There are some important changes that took place with C-56. But in the past, in order to prove that somebody was in a dominant position, you had to establish 3 criteria. First, you had to demonstrate that a company was dominant. 2, that there was an anti-competitive behavior. And third, that behavior had an impact on the market. With this bill, and you still have to prove that there's a dominant position, but if you can prove only one of the 2 other criteria, so either that there is a behavior that is anti-competitive or the other, then you can actually bring it to court. So it's a big change. There's also penalty fees. With the market studies that we have now, eliminating certain criteria will make a difference so that the Competition Bureau is in a better position in order to protect competition going forward. Here's what I hear, or what I'm hearing, and please confirm. In the law, is it true that a company will be forbidden from selling a product at a price that is lower than the production cost? That is a strategy that is often used by various grocers. Is that going to be forbidden under the new law? No. There's no change concerning the strategies, such as loss leader, that retailers can use. What's always existed in the law is anti-competition or anti-competitive behavior. What we call it is predatory pricing. It's when you price a product lower than what it should cost, and the point is to eliminate a competitor instead of seeing competition between various competitors. In specific circumstances, it could be a predatory practice that is meant to eliminate a competitor altogether. And in that case, it would be a dominant position, a case of dominant position. We're at time. Now on to Mr. Perron for 6 minutes, please. Thank you, Mr. Chair, and thank you to the witnesses for your presence. We're happy to see you again. Things have changed quite a bit since we last saw each other. There was a bill that was passed, and you were talking about C-56 with Mr. Drouin. But here's what I want to ask. Is C-56 enough? Does it go far enough to really change things, or is there anything missing? I'd say that C-56 was very important for us. The changes were important and brought Canada to a level that was comparable to other countries with regards to how the law is applied. C-59 brings modifications or amendments to the Competition Act, which are quite important as well. In our opinion, there's always more that we can do to make the law even stronger and make sure that it is modern and efficient. The Bureau made more than 50 recommendations during the government's consultation period. We really went through some important steps, but there's always more that we could do. Sorry to cut you off. You said that you're happy with C-56 and C-59 is going to be positive. you've made recommendations to the government. Can you tell us what some of your recommendations were, or can you give 2 or 3 recommendations that would be essential in order to strengthen the bill? There are recommendations that are not included in C-59. There are many that come up over and over again. To refer to Mr. Williams' question, it's important that there are laws with regards to mergers and to protect competition under mergers. Here's an example. There's a test to correct transactions that have an anti-competitive impact on the market. The corrective measures and the legal test currently is the following. If there is a transaction that diminishes competition, the corrective measures just are only there to make sure that they're no longer sensitive. So in a way, it's okay that there's less competition, but you can't correct that competition to make sure that it comes back to what it was before the merger. So that was one of the recommendations that we'd made during the consultation. There are other recommendations that talk about the thresholds of concentration. For example, if there was a presumption of concentration, or if we go beyond a certain threshold, the company then has to prove that the transaction is anti-competitive in nature. That's similar to what's done in the United States. What is the ideal threshold? Does it depend on the market? Indeed, it does. Thank you for these recommendations. We'll make sure that they're taken into consideration. So I'm listening to you, and you seem like good-willed people and well-informed, but the structure means it looks like it's more about appearances. We're making progress, but it's quite slow. At the government, there's a lot that's done. There's a lot of smoke and mirrors. I'm listening to what you're saying, and you're saying that we have to be careful, but I'm looking at the history of mergers in the grocery industry. Even as a citizen, not even as an MP, I can't help myself. I wonder, what did they do? Across the 90s, the 2000s, 2007, 2017, and so on, all of these dates, there have been transactions during all of these dates. We had 13 grocery stores, and now there are 3, and now there are 2 American ones that mean that we have 5 major grocery chains, but it really resembles an oligopoly. It's quite a shame. I know that you don't have much power, but you did exist. I'm not accusing you personally, but I'm questioning the structures in place. I was listening to my Conservative colleagues' questions, and it's very upsetting. Correct me if I'm wrong. You said that Rogers and Shaw, you said that you were against the merger, but it still happened. So who makes that decision? Who's at fault? It's the courts. With Rogers and Shaw, we brought an application to the competition tribunal to block the transaction, but the tribunal is like a court. They receive witnesses, they look at the evidence, and they decided that the transaction could continue. So what we'd have to do is change the laws that are interpreted by that tribunal. This makes no sense. We're looking at this situation that is completely unacceptable for all citizens. It just happened in a different industry. I'm so sorry to be so upset this morning, but it really grinds my gears. If you had any recommendations to make on the laws that should be changed, that's what you mentioned earlier, but if you have any that you think are essential, and if you can provide them to the community in writing, that would be highly appreciated. And thank you again for collaborating with our committee.
Patron said, I think this committee would benefit from having some of the recommendations that ultimately didn't find their way into legislation, particularly the most pertinent. Maybe that's a submission you can make independent of your testimony here today. Mr. McGregor for 6 minutes, please.
Thank you very much, Mr. Chair. Thank you to both of you for appearing before our committee. Ever since this committee embarked on the study back at the end of 2022, there has been a flurry of activity. We have seen several pieces of legislation. We've seen your Bureau act. There has been a tremendous amount of public and political interest on this issue. And I think after decades of far too much corporate deference from both successive Liberal and Conservative governments, I think the pendulum is finally swinging the other way, and that's a good thing for consumers. You are from the competition promotion part of the Competition Bureau, and my colleagues have outlined how, three companies have, in a sense, over the last number of years, they've swallowed up their competition, and you just need to look at all of their subsidiary companies. Many of those used to be their competitors. I'm just wondering if briefly, what are the challenges for you in this kind of environment to promote competition when we have had such a concentration over the years? We've all seen the direction it's taken. How do you promote competition in the grocery sector with those realities having happened?
Thank you very much for the question. I think we promote competition relentlessly, and we try and be as persuasive as we can because we think the evidence speaks for itself. Competition is good for consumers, lowers prices, leads to innovation. Competition is good for the economy. We have a productivity issue in this country. We firmly believe, and the evidence is clear, that competition is the key to unlock this and really stimulate economic growth. What I would say, so my colleague Mr. Callahan and I are in the business of promoting competition, and there's a lot of positive coming out of the last year, and it really feels like the pendulum is swinging, not just only in terms of our law and strengthening our law, but the discourse. We're starting to see parliamentarians in particular speaking about competition, holding companies to account. It makes a difference, and we're seeing this. The Globe and Mail had a really good editorial a couple of days ago where their editorial board spoke to this shift in the culture and the tone in Canada about prioritizing competition. Our desire is that this continues, and we're going to work very hard to make sure that we continue to have these discussions in Canada because they're very important.
Yeah, no, I think you're right. And case in point, Loblaws had to climb down from its tone-deaf decision to reduce discounts from 50% to 30%. And then, of course, we had Manulife and Loblaws. That climbed down because of the intense scrutiny, I think, that exists at the moment. You've made mention of a couple of pieces of government legislation, C-56, which has received royal assent, C-59, which is still in the works. But there's another bill that received a second reading vote yesterday, C-352 from NDP leader Jagmeet Singh. There are some similarities, but one of the interesting aspects of his bill, and I know this primarily deals with the Competition Tribunal, but it would require the Competition Tribunal to make an order dissolving a completed merger or prohibiting the merger from proceeding if the merger would result in excessive combined market share. I would just like to understand the Competitions Bureau, your understanding of that term, excessive combined market share. How would you interpret that particular phrase in the law?
We'd want to give that some careful thought, and if and when we appear at Indu Committee for the study of that bill, I think that we'd want to be as helpful as we can in terms of the interpretation. But part of these issues come to something that we've advocated for is the potential benefit of structural presumptions. So, and this is how the U.S. jurisprudence around antitrust has evolved. And it's basically the notion that past a certain increase in concentration and threshold, that the onus should shift on companies to prove that it is not anti-competitive. And that's certainly a discussion worth having. There are changes in Bill C-59 that are important in that regard. So we're removing a requirement that existed in Section 92 that we could not challenge mergers on the basis of market shares or thresholds. So there might be a greater role to play in looking at market share and concentration in our work. Of course, there are other factors that are always going to be relevant, looking at barriers to entry, effective remaining competition, the role of innovation in the marketplace. But, we hear that there are significant concerns about concentration in the Canadian economy, and we think it's important to debate these issues, and especially when we look at our merger review framework and the law.
Yeah, no, I think like grocery companies, because of their concentration, they know that many Canadians are creatures of habit, and they will just continue to going to the same store, and so they, in a sense, have a captive audience once you're stuck inside the store. Just very briefly, we're doing a second round on this study because Minister Champagne has been talking a lot about his disappointment and efforts to stabilize. In relation to his most recent end of January letter, what actions did that prompt the Competition Bureau to take when you saw the letter from Minister Champagne?
You're referring to his letter from last week, January 29th? Yeah. So it's obviously a letter we took very seriously. And what I would say is I think we're an independent agency, but I think our interests are very much aligned, that we want to protect and promote competition in this sector, and we truly are prioritizing our work here in a couple of respects. One is the findings and recommendations of our market study. We continue very actively to work with policymakers, including provincial and territorial governments, about them in the hope of enacting some of these recommendations because they will make a difference. The other component is our enforcement role, enforcing the law and making sure that work in the grocery sector is really front and center. And as I mentioned, we have an active investigation in the grocery sector related to property controls or restrictive covenants, and we will continue to prioritize this work. So it's a letter we took very seriously, and I think we're very much aligned in prioritizing grocery prices and competition here.
Thank you, Mr. McGregor. We'll now turn to Mr. Barlow for 5 minutes.
Thanks, Mr. Chair, and thanks for being with us once again. It's much appreciated. I know in your report, I know you don't study the grocery code specifically, but you do mention in your report that it would be a benefit, more accountability. Mr. Weston from Loblaws, when he appeared at this committee, said the grocery code of conduct will cost Loblaws $1 billion. In any of the work that the Competition Bureau has done, do you see any data in the grocery code that would verify that comment that this would actually cost, or the cost would be devastating to the grocery chains?
Thank you for the question. So we're certainly familiar with those statements. To answer your question directly, we have not seen anything that would make the Bureau concerned in that regard. I think if we thought that the code could result in significant price increases, the Competition Bureau would be concerned and we would share that. But right now, the truth of the matter is we've been keeping our finger on the pulse of the code. We talk with stakeholders about it and have reviewed it carefully. We have not seen any red flags. Our role, as we see it with respect to the code, is as a competition advocate to provide a pro-competitive perspective on its implementation, should it be implemented. And our position on the code has been that if it can lead to greater predictability, transparency, and certainty for suppliers in particular about how to conduct business in the sector, that can be a good thing for consumers.
The Minister of Innovation had made the comments that he's looking at trying to attract international companies to come to Canada to add to that competition. In the same news article, it was interesting, I saw Target came to Canada at a massive footprint, invested $8 billion and lasted less than 3 years, even though it had all the Zellers locations. How is it possible that a company like Target, so for the innovation minister to say, we're just going to get another company in here to add competition when it's been tried and failed? How do we expect a small Alberta company like Fresno's to grow and have an impact? What are some of the impediments that you're seeing that are keeping some of these companies, A, from coming, and B, being able to be successful long term?
And certainly the Target experience came up, and we mentioned it in our report in terms of something that international grocers told us when they look at the Canadian market, because we asked them, what are the barriers? What's keeping you out? What are some of the reasons? Target was mentioned. There are other factors, too, that related to it. One, perhaps in response to your question, I can mention is restrictive covenants, property controls. So that is something that really can be a major barrier to entry and expansion in the Canadian marketplace, because they make it, you can't start a new grocery store if you can't get access to land. And that is something that we heard particularly from independents as being problematic. And that is why one of our recommendations in the report, and this is something that a number of other countries have done, is to consider limiting their use or banning them altogether in the grocery sector, because they can be harmful to competition. And of course, we also have an enforcement interest in the space as well.
On that same sort of theme, I don't know if you've had those conversations, but in some of the work that you do, you say you're trying to promote that competition, which is critical. Do other companies look at the landscape in Canada in terms of, we talk about front of pack labeling changes, P2 plastic bans, carbon taxes. Do they look at just seeing Canada as not a clear path to success with some of the regulatory burdens that may be there?
It's a difficult question to answer, because every industry, every company's calculus, when they look at the prospects of investing and entering Canada, is different. Fundamentally, the Bureau, we believe in the importance of pro-competitive regulations, and we're constantly trying to provide advice to governments at all levels in that regard. In some instances, it's removing regulations. In others, it's making sure that regulations are smart and promote competition. One example is open banking, right? Like, that is, from our perspective, smart and important regulation to unlock competition in financial services. So all that to say, I think every industry is different in terms of how companies are assessing the viability of entry and the role of regulation. And our job is to try and advocate for smart, pro-competitive regulation and lower barriers to entry when we can.
Thank you. Thank you very much, Mr. Barlow. Thank you very much, Mr. Durocher. We'll now turn to Ms. Taylor-Roy for up to 5 minutes.
Thank you very much for being here. And indeed, it's good news to hear the pendulum is swinging and that food prices are coming down more in line with general inflation. And that Bill C-56 did help. We also have Bill C-59 right now under consideration. And you mentioned that there were aspects of that bill that you thought would be very helpful in continuing to combat obviously the concentration and issues around competition. What in particular would those aspects be?
Specific to the grocery industry or just more generally?
Generally, but if it has an impact on grocers, I think that's our main focus here, is making sure Canadians have lower food prices. So
one of the most important changes flowing from Bill C-59 is opening up the Competition Act to more private enforcement. So not just the Competition Bureau being the sole authority who can bring cases. So there are changes there that I think are capturing a lot of interest from stakeholders in the competition space. So the role of private enforcement, the test for obtaining leave has been clarified. So what we might see emerge there is a more robust space where private actors can bring cases directly to court and not just being the Competition Bureau. As I mentioned, in respect to mergers, there are certain important changes. One is to allow greater emphasis on market share and concentration evidence as well. Another are important changes to Section 90.1, which is the competitor collaboration provision of the Competition Act. So an ability to look at past conduct. It allows for a broader range of remedies, too. So these are examples. Also, to give an example, one very interesting change relates to reprisal action. So it adds a new civil provision that would prohibit a party from taking reprisal action against another person for their cooperation under the Act. And that is a very interesting change and potentially important, because whenever companies complain to us, there's always the concern about reprisal, right? If you're complaining about the actions of one of your business partners, obviously confidentiality is paramount to our work. It's something we take extremely serious and protect. But additional protections and peace of mind about lowering the risk for reprisal action is important. So these are just a few examples, but there's a lot to cover with C-59.
Thank you. And yeah, C-59 we've been trying to get passed since the fall. And the Conservative Party has been very against C-59. I'm wondering, recently we found out that Jenny Byrne, who is advising the Conservative Party and joins their caucus advising their leader, is actually a consultant or a lobbyist, we could say, for Loblaws. So I'm wondering, these changes, it sounds to me Loblaws might not be in favor of some of these changes. But it seems that C-59 is very important. And would you recommend, from your perspective, from the Competition Bureau, that C-59 actually be passed so that we can get these measures in place?
Well, I think the way we're going to approach C-59 is if and when we're called to committee, we will certainly provide our views. But as I mentioned and was in our opening statement, there are important improvements the Competition Act contain there. And what we really want to do is help inform parliamentarians and provide whatever evidence we can at committee that's going to help deliberations.
So at this committee, we're looking at grocery prices, and there's been progress, but we want them to come further, and we want stability.
Yeah.
So from your perspective, would this be, in this study, recommending that the changes in C-59 be adopted? That would be useful in addressing some of the concerns you have.
Yeah, I think it's fair to say that some of the Competition Act changes proposed in Bill C-59 are certainly desirable and frankly in line with some of the recommendations that we made in the government consultation on the bill.
Fabulous. Thank you very much. Do I have any more time, Chair?
Well, you have about 15 seconds, but
No,
I know
I'll give
you're
it back
gracious.
to you.
You'll give that back to us. OK. Maintenant, Monsieur Parent, 2 minutes 30 secondes, s'il vous plaît.
Mr. Parent for 2.5 minutes. Thank you, Mr. Chair. Mr. Durocher, you know that the CEOs of Walmart have already been here twice. The first time they came here as witnesses, we knew that you were going to do a study, and I asked them to commit to giving you the necessary data, and they all promised that they would. Of course, I was very disappointed when I saw in your report that you were unable to receive the data, even though you asked repeatedly. You probably can't tell me who didn't participate, but of course it's great for us to have to... It's interesting. They come here and they tell us that they've all provided the necessary data, whereas you're telling us that they didn't. So would you be able to tell us? I have my own doubts because there are some participants that don't want to sign the grocery store code of conduct, so it's a little bit suspicious. But what is the nature of the documents that they refused to provide you with? And next time, they will be obliged under this new law to provide them to you. The level of collaboration really did vary, and it's on a spectrum. On one hand, there are some companies that did willingly participate and give us, in good faith, the information that they could. And then there are companies that had many excuses as to why they couldn't give us the data. Most of them gave us information, but it's not necessarily what we wanted, nor was it what we asked for. There's a big difference in their level of cooperation. One company didn't give us any information. They only gave us information that was already public. We determined that we still received the information that was necessary to make the recommendations that were strong. I'm sorry to interrupt you, but you can't tell us who that was, right? No, I can't. But your response is clear. Now, there are groups that don't want to sign the grocery store code of conduct. Most of them were not even at the table. They were represented by other organizations. They only get involved at the very end of the process, and they ruin things. What do you think of a code that would not cover 100% of the market? Do you think it could work, or do you think that it will be a failure? It's difficult from our perspective to say what would be achievable. I understand if some companies have certain reservations. It's unequal. There could be an unequal competitive advantage on the market if some companies participate in the code and others don't. That is possible. What I'm trying to say is that we're keeping an eye on the code, but we have not yet studied whether or not it should be mandatory. We're collaborating. We're communicating with our government partners with regards to the code, and we'll keep an eye on how things unfold. Thank you, Mr. Durocher and Mr. Perron. Now we will have a third round of questions, but on to McGregor.
2.5 minutes. I just wanted to let everyone else know.
Thank you, Mr. Chair. This last couple of years has just been incredibly frustrating for so many Canadians. The constant rise in food prices, and they can see from the publicly available data from Statistics Canada, which one of our witnesses, Jim Stanford, provided us. The food retail profits have doubled since 2019, and even the margins. And, every time people go shopping, they're seeing increasing prices. I have noticed personally, too, that many of the food items I purchase, the net weight has gone down, and the price has either remained constant or sometimes has gone up. So it's a double insult. So there's an incredible amount of frustration out there. With regards to the study that was released in June of 2023, how would that study have been different, or how do you think your conclusions would have been different if you had the powers that you now have under C-56? Does the Competition Bureau, do you feel like you would like to revisit that study and maybe make use of the new legislative powers? Can you just maybe explain the differences that now exist?
Yeah. So certainly now with the changes that have been made, we can go seek a court order to compel the information to complete a study. So it's difficult to hypothesize as to how it could have been different had it have played out. But fundamentally, I think we were satisfied that we got sufficient information from the marketplace, and what we asked for, not everything, but sufficient to make meaningful findings and recommendations. And right now, I think our frame of mind as an organization is we want to move from study to action, and action by implementing and working with policymakers to implement the recommendations, and also focusing and prioritizing enforcement work in the sector to protect competition.
And do you have plans to revisit the issue, or can the Canadian public expect more studies in the future? Is that something you're actively working on? Conclusions.
So I think everything is on the table right now in regards to our work in the grocery sector. But one issue that is a consideration is where can we provide the most value for Canadians? We don't have infinite resources as an organization. We are prioritizing the grocery sector. Where do we give the most value of looking at? And again, right now we're very much solution focused on the implementation of our recommendations from the study and looking at enforcement work in the space as well and driving those forward. But nothing is off the table. We're obviously very mindful of Minister Champagne's letter from last Monday that asked us to prioritize and made mention of a potential follow-up study. I think these are all on the table, but we truly want to be focused on solutions rather than maybe more study of the sector. But nothing is off the table.
Thank you.
Thank you, Mr. McGregor. We'll go to Ms. Rood for around 5 minutes, and then we'll have Mr. Lewis after that.
Thank you, Chair. At the Industry Committee in December of 2020, I had the opportunity to ask Mr. Matthew Boswell, Commissioner of Competition, some questions. And I told the Commissioner the Prime Minister had said that he was going to ask the Competition Bureau to investigate the fees that are charged to producers and processors by the grocery giants. And I asked the Commissioner if he had launched an investigation. And Mr. Boswell said, and I quote, "The Bureau is very much aware of these issues with respect to retailers and their suppliers, and we are already engaging at the federal, provincial, and territorial level with respect to this issue, sharing our expertise on competition issues," unquote. So I'm just wondering, was there an investigation to the fees charged to producers and suppliers by the grocery retailers? And if so, what were the findings of that investigation?
Yeah, thank you for the question. So we had a very comprehensive abuse of dominance investigation into Loblaw that culminated in, I think, 2017 or thereabouts, about the policies and fees that were being as part of its dealings with suppliers. Following, over the course of our review, Loblaw stopped many of the practices in question. We concluded the investigation and published a pretty detailed, what we call position statement, to provide more transparency on the nature of our investigation, but also where companies can cross the line in their dealings with suppliers where they might run afoul of the Competition Act. Since that time, there has been work in respect to the Code of Conduct, really aiming to address that, and I think we've been privy to these developments and trying to share our knowledge of the industry, our knowledge from our investigation, and it is a fine line as between when there's an imbalance in bargaining power between parties and what crosses the line to an abuse of dominant position. And a lot of actions in this sector might be more defined as an imbalance in bargaining position and some of the problems emanating from that, not necessarily a competition law problem, but we continue to work with governments at all levels to try and inform and lend our experience with some of these issues in the sector.
Great. And on that, actually, the commissioner indicated that at that time, and I'll quote him, competition law in Canada does not provide for a tool to regulate imbalances in bargaining power, unquote. So does the Competition Tribunal now have any power to investigate or regulate imbalances in bargaining power, or what tools do you need in order to do that?
Typically, competition law, not just in Canada but elsewhere, is not really meant to address imbalances in bargaining power, be it a large company, how it deals with suppliers or customers. In the sense that it could be a large company that imposes unfair prices on suppliers or unfair fees or charges high prices to customers. That is not offside the Competition Act. What is if you abuse your dominant position by taking steps to undermine competition and make it so that competition isn't working by raising barriers or excluding competitors. So it is a fine line between the two, but typically competition law is not meant to address imbalances in bargaining power.
Okay, and you mentioned the Grocery Code of Conduct. So I'm just wondering if you believe that if the Competition Bureau believes the Grocery Code of Conduct should be mandatory or voluntary then?
It's an issue we haven't studied in any depth as to the prospects or desirability of having a permanent code. I mean, we do note and we are aware that in the UK, they do have a code. It started as voluntarily and then became a mandated code to ensure compliance. How this is going to play out in Canada is something that we're going to continue to be made available and to make sure that it's as pro-competitive as possible. But mandatory versus not is, in all honesty, not something that we've studied in any depth.
Thank you. My last question. We've been talking about the government's new P2 plastics ban and what that would have, the impact that it would have on Canadians on the costs of groceries. We've heard that it could cost upwards of $6 billion, and we import 2/3 of our fresh produce into this country. So I'm wondering if the Competition Bureau has looked at all at the new proposed plastics ban on the fresh produce industry and how that would actually impact competition, getting product here to Canada on the grocery store shelves for Canadians, and the price that it may affect.
Yeah, thank you for the question. That is not an issue that we would have studied or looked at.
Thank you very much. Thanks. Mr. Chair, just before I give up my time, I'd actually like to take a moment to table a motion today in this committee, because we have talked to many different witnesses who have said that the plastics ban is going to have a very profound effect on the price of food for Canadians. And while we're looking here in this committee to try to lower the price and what we can do to lower the price of food for Canadians, we have government policy coming out that is actually going to increase the price of food for Canadians. So I do have it, and I can send it to the clerk in French and English, but that this committee begin a study on the impacts of existing and potential regulations on primary food plastic packaging in respect to the production, processing, transport, transport, retail marketing, sale costs, and safety of food products, and the impact on access to healthy, affordable food and food security for Canadians. That this committee allocate no fewer than 6 meetings to hear from stakeholders and witnesses before the committee, and that this committee report its findings and recommendations to the House no later than June 1st, 2024.
Thank you, Ms. Rood. I know we're looking at studying the horticulture sector in the next couple of weeks, so we'll talk as a committee about whether or not we move forward with your motion or that can be incorporated into some of our existing work plan. But thank you for that. We'll now turn to Mr. Lewis for up to 5 minutes.
Thank you, Chair. Thank you to the witnesses for being here. It's important to have conversations with the Competition Bureau. We're hearing the word imbalance a lot, and your position is to potentially look into that, abusing a dominant position. That's what you said. To shape this legislation that we've put forward and also one that's passed, there were many consultations. I think about 400 submissions, a dozen roundtables. It took about 18 months, and it's a focused and targeted, and we got consensus from many perspectives, the industry, academics, and advocacy groups as well. One of the barriers, in my understanding, that the Commission faced in your investigation of concentration in the grocery sector was your limited ability to compel documents from the grocery chains as part of your probes. C-56 will give the Competition Bureau the ability to do that, as well as give more market study powers, subpoena powers, to compel those large grocery chains to get more information, which is going to address the lack of transparency that we're seeing from these grocery giants. They had submitted confidentially, gave us the reports and information of various degrees of transparency and thoroughness. So how can the new powers that you have help your office to issue stronger and more informed recommendations and decisions?
I think going forward, to enable us to do complete and thorough market studies in all sectors of the economy that warrant study, because because there's competition issues, or we want to look to increase competitive intensity and find out what's going on in a sector. These studies are going to be these study powers are going to be helpful and are very much in line with what many of our foreign counterparts already had with their own competition laws. So it will absolutely be an important tool to equip us to make fully informed recommendations and determinations examining competition.
Do you tend to see that the larger these corporations get, the easier it is for them to resist being transparent, and they have more pushback as they're consolidating more and more?
Well, every company is different in terms of how they interact with the Competition Bureau. Some are more forthcoming than others, and they all have different incentives at play. What we've come to see is, it's important to have it as a tool that you can use as a recourse. Not to say, so in our enforcement work, we've always had the ability to issue subpoenas or go to court to get subpoenas. Sometimes you don't need to do that because companies know that that's a possibility and are fully going to cooperate. So it's hard. Obviously, it's going to change the nature of the calculus for companies, because before C-56 for market studies, the fact of the matter is it was voluntary cooperation, and we did not have recourse. If they didn't want to cooperate fully, there was no recourse. So that changes going forward and is certainly going to be a helpful tool for us.
That's good to know. So just the fact that you can use that tool is something that will help these companies to comply with what you're asking for, which is only what Canadians are asking for, which is transparency and obviously competition, which would lower prices. Your report, you mentioned stimulating innovation, supporting independent grocers, unit pricing requirements, and property controls. In order to protect our independent grocers, I wanted to talk about property controls. You had mentioned that, like restrictive covenants. It's going to limit competition in the sector, and these controls have prevented independent grocers from opening up in our communities, and that less competition, less choice, and higher prices. So how will the Bureau's ability to challenge these controls and agreements, like restrictive covenants, help competition in the grocery sector?
So you're absolutely right. This was a topic of focus that we covered in our report, and as Mr. DeRoche mentioned, they at their essence are things that limit what a property holder can do with their property. Oftentimes, these are included in leases or things of that nature, and the effect is they can ultimately just make it harder for a competitor to get into the same space. It could be the same commercial mall, but it also could cover a wider geographic area. But the impact is the same. It can make it harder for an entrant to get in and compete. So there's really kind of a couple of ways that we're thinking about how we can improve competition in this space. One is by using our enforcement mandate. And as Mr. DeRoche mentioned, we do have an active investigation in that space. We've also recommended that there may be legislative options for governments out there to think about limiting the use of these property controls or to ban them entirely, which would obviously be an instrument that would have a much broader effect, whereas the Bureau's work is much more on a case-by-case basis and would obviously have to determine the facts to make sure that it would be in violation of the Competition Act.
Thank you very much. It's just we've heard it from our study, the importance of protecting our independent local grocers too. So thank you. Thank you, Chair.
Thank you. Colleagues, I'm just going to take a few minutes. I was particularly interested with Mr. Williams' line of questioning to start off, and he talked about, of course, mergers and acquisition as being somewhat anti-competitive or has the ability to be. I appreciate your comments, Mr. DeRoche, which is it's kind of dependent on the facts in a particular industry. Can you tell this committee, because again, there was a focus on how there has been a consolidation in Canadian grocery sector, but how would that compare elsewhere in the world? I would expect that there has been elsewhere consolidation in this sector as well. Is that a fair assumption, or would I be wrong in that suggestion?
I think that's fair. Maybe I'll make a couple of points here. One is other countries often had stronger merger review laws than Canada to begin with, so may have been in a position to take action against concentration more so than we had prior to this legislative modernization. But the other is, in the context of our grocery market study, we contacted a number of our foreign counterparts to get a sense for what is going on in their own jurisdictions with respect to this. And concerns about grocery concentration and pricing are very much top of mind in a number of other countries. And with their competition authorities looking at these issues too. So, I mean, the reality is Canada is not alone, and we do speak with one another, but very much mergers, it's really the small proportion of mergers that are harmful that we want to make sure we have the right tools to address. The vast majority of mergers don't harm competition, but it's really the small proportion that do, and especially in concentrated sectors, that we want to make sure that the Competition Authority is well equipped to swiftly bring cases and handle those.
Let me ask you about this just quickly on the efficiencies defense, which I believe the government is part of working on phasing that out. You know, I have a commerce background. There is, I think, an interesting tension between economies of scale, which can actually bring down unit price production and potentially cost. I can appreciate it can also lead to a situation where the price mechanism can be controlled by a few companies that have that market power and that market dominance. How do you balance what is like legitimate elements around economies of scale and the ability to make sure that your cost of capital can be dispersed out over a larger market share and the unit price actually can come down, versus an efficiencies defense where it can also be monopolistic? Like, where's that balance? Can you try to explain to this committee? Because would you agree that there is some element on economies of scale, the idea that there isn't some concentration that can be good, but too far can go the other way as well?
So the efficiencies defense is now no longer exists. When Bill C-56 became law, it is no longer there. So it was repealed. The problem with the efficiencies defense, I mean, one of the problems, there are quite a few, was that it allowed harmful mergers. So mergers where we could prove that it's going to lessen competition and prices are going to go up and it is harmful to consumers in the economy, that defense, the way the jurisprudence evolved, would go through. And that Canada was very much an anomaly in terms of how we looked at it. I think going forward, there is certainly scope for mergers that are can be pro-competitive, where you have two companies that are bringing their resources together, and it's actually can be good for competition consumers because it can stimulate competition. Every case is different as to the net effect of that and how they're going to use resources and how they can argue that it is actually good for competition and pro-competitive. But it is, since the passage of C-56, it is a new day for how efficiencies are viewed.
Last one, Mr. McGregor talked about Manulife and shoppers, which was the idea that I guess folks that were under a Manulife plan were only going to be able to buy. Would that have been a prima facie case of non-competitive behavior? Like, I know Mr. McGregor talked about the company backing off, and that might not actually be coming to a reality, but would that have been something that would have triggered the Competition Bureau to intervene and actually could have been contrary to competition law?
Thank you for the question. Obviously, this is something that was very much in the public discourse in the spotlight last week. We were very much monitoring very actively. Because of our confidentiality obligations, we can't and we received a lot of media inquiries as well. All I can say in respect to that agreement is it was very much on our radar, and in part because protecting access and affordability of prescription drugs is an absolute priority and important for Canadians. And so these are things that were very much top of mind when they came to known. And I'll just add that to come back to Mr. McGregor's question on this, that this is one where we've seen the discourse around competition and the backlash perhaps showing that we're really prioritizing competition more in our economy. And from our perspective, that's certainly a welcome change.
Thank you very much, colleagues. I thought great lines of questioning from all sides, and thank you to the Competition Bureau for being here, Mr. Durocher and Mr. Callahan. Colleagues, we're going to be going in camera to do some committee business, so I'm going to suspend for 2 or 3 minutes. Mr. McLeod and Mr. Carr, make sure you hop on the other link in a virtual mode, and colleagues, will see you in just 2 or 3 minutes. Meeting suspended.